Do you anticipate further evidence?
I'm sorry?
Do you anticipate further evidence?
I anticipate, Your Honor, offering the exhibit that we had previously offered of Grant in the interview room at the Raleigh Police Department.
Okay. Do you anticipate calling any additional witnesses?
Yes, I'll have someone, and I would ask that.
I just want to know how much. I want to know, for our planning purposes, do you have additional evidence by calling witnesses?
One more witness.
Okay. Do you anticipate rebuttal evidence?
Yes, sir.
How much?
One witness.
Okay. All right. The jury is absent. Mr. Gaskins, tell me. How you contend that statements made by Grant Hayes to law enforcement officers, or just some view of Grant Hayes while he was in custody, is competent, admissible, and otherwise probative with regard to the charges in this case regarding your client?
Your Honor, we contend that there's been evidence that Amanda was afraid of him, that he was becoming more and more paranoid, that he was acting more and more crazy as they got back to Raleigh. The tape of him while he is alone in the interview room, believing that no one is watching him, displays evidence of an individual who is mentally and emotionally disturbed, confirming what she was observing was happening as they were returning to Raleigh.
But she's not charged with the commission of any crime that occurred after they left Texas. And his mental state after they left Texas is really not an issue in this lawsuit.
I think her perception is what is important. Her perception of what the dangerous individual that she is having to contend with on the trip back from Texas to Raleigh.
But she's not charged with having been an accessory to this crime for any conduct that she committed on the trip back to Raleigh from Texas, or any conduct that she engaged in thereafter. She's only charged with conduct relating to the events that occurred prior to her arrival in Texas and in Texas.
As I read the indictment, she's charged with providing aid and assistance to him after she knew that he had killed Laura. I don't recall anything that specifically says only what happened in Texas.
Well, but I don't think there's any evidence before this court that would support any contention that she engaged in conduct either on the trip back or after that would constitute accessory after the fact to homicide. Do you contend that there's any conduct that she engaged in either on the trip back or after she came back to North Carolina that would constitute evidence of accessory after the fact to homicide? Well, there's certainly any evidence. I haven't heard any evidence to that effect.
Your Honor, if I may be heard briefly, the state made a big point to show photographs of Amanda Hayes in a hotel room, seemingly smiling, that we contend she looks haggard. They have put this directly into evidence, or this into relevancy about her state of mind in relation to how Grant is manipulating her, controlling her, and threatening her by presenting those photographs. Without doubt, they want to argue to the jury that she was not in distress, that she was not under duress.
Well, I know, but it's my understanding that your contention with regard to duress is that she engaged in the acts that would constitute the crime of accessory after the fact of murder, and she committed those acts solely because she was under duress and in fear, as I understand the law of the state, that she would suffer or another person would suffer immediate death or serious bodily injury if she did not commit those acts, as I understand the law of the state. And you're telling me that it's her observations of Grant Hayes after they left Texas are such that this is relevant on a claim of duress concerning accessory after the fact to murder?
Yes, Your Honor. Obviously, the most probative evidence would be evidence about Grant's behavior and actions around the 19th and the 20th when the body is dumped into the creek and immediately thereafter. But under relevancy, Your Honor.
And when she's alleged to have committed acts that would constitute accessory after the fact of murder, that you contend are excused because her conduct was involuntary, because she contends that she was reasonably in fear of immediate death or serious bodily injury to herself or another person when she committed those acts.
Yes, Your Honor, but ultimately what happens a few days later in the hotel on the way back to North Carolina, there's no break in time. This is that she is still with Grant. And I think the state's presentation of the photographic evidence drives home the relevancy issue, that they're saying that she wasn't under duress at the time she's with Grant while he's dumping the body in the creek, by showing evidence of a few days later, she, while looking haggard, is smiling in a photo. They have made this highly relevant, this issue about her state of mind as it goes back to, and Grant's state of mind as it goes back a few days earlier. And since you have no disruption in time between Grant being with Laura and vice versa, it is still probative evidence. You know, as Your Honor knows, relevancy is a low bar. It's probative evidence of how Grant likely was a few days earlier. In other words,
when he is in custody, is relevant evidence of how he was a few days earlier when he was not in custody?
We believe that's a question for the jury, Your Honor, with all respect.
Well, I mean, I haven't seen any of this, so how about telling me what you believe this is going to show? I don't have a clue what it's going to show. Sounds like long periods of silence.
It's more than that. He's singing, rambling. It is statements where any lay person would think he has lost his mind, and he is just not thinking rationally. He has disturbed thought disorders. I mean, it is consistent with who we contend to be a maniac psychopath.
All right. Let's take what we heard.
Yes, Your Honor. I think the difference between those pictures and the hotel is that Amanda's there with Grant, and at that point, that's why that's relevant. At this point, what we're talking about once he's in custody, is how he reacts to being placed in incarceration and sitting in this room where he's being videotaped and folks leave the room. That has no probative value on its effect on Amanda's state of mind. And I would argue to you that it's got a pretty minimal effect on Grant's state of mind, considering that he's sitting in this room for some 6 hours, and after all these activities, I would argue that there's very, very, very little probative value. As a matter of fact, there's no probative value to anything relevant to this case.
Your Honor, one more point. We'd like to say he is singing. He's talking about aliens. These are things that corroborate a large part of Amanda's testimony, that he was becoming more and more paranoid, where she's fearful he's just going to explode at any second. This has a strong tendency to corroborate that, which all goes back to the most relevant point in time, which is for the accessory charge, which is the 19th, and then immediately
Well, what
after.
part of this do you intend to offer?
Your
I mean,
Honor,
obviously, there's a lot of the things in there have would have no probative value, but were there events that occurred during the course of this time that he was in custody that are you contend significant?
I would, following up on comments Mr. Clausen made, there are certain periods of time where he is singing and obviously not rational, but he also gets into some ramblings and some talking about aliens and things of that nature, which directly corroborate information that Laura Ackerson had provided Dr. Calloway through her parenting history survey, and Dr. Calloway, which is their witness, has testified, and through the child custody evaluation, that she had observed him with rambling, tangential talking and thinking, and his thinking was illogical and disturbed, and had recommended psychiatric treatment. And so this video is certainly not the whole 6 hours, but the parts of that video that directly connect and corroborate.
Well, how much of it is it?
Mr. Gaskin.
Your Honor,
How much of it is it?
well, there's a 61-page transcript of conversations that he's having during the time that he's in the interview room, although there are long periods of silence while he is on the tape. What we would propose to do is to play the tape and have the witness read the transcript. You can barely hear him on the tape itself. The transcript was prepared from the tape. We don't propose to play 6 hours worth of tape. We propose to play the tape as it's moving along, but have the transcript read as the jurors are viewing his demeanor.
Through what witness? Through what witness?
Detective Falk.
Okay. Do you intend to direct Detective Falk's attention to everything in that transcript?
There are some things in here that probably don't have relevance to our point. For example, there's some conversations between him and police officers. We don't intend to ask about those questions. We do intend to ask about the things that he's saying when he's in the room by himself, believing that he is not being heard.
Have you highlighted that on any kind of document that you can show Detective Falk if you call him to the witness stand?
I'll have to do that, and I have not done that yet. I can do that quickly so that we don't go through the unnecessary parts. It'll only take me a few minutes to do it.
All right. Can be heard further?
Your Honor, I would just say that if the whole point of this is to show Grant Hayes' mental state. So his response to police officers when they're interrogating him and asking about stuff and he requests an attorney, that's not appropriate to show his mental state. But these parts that we're going to pick out are appropriate. I'd argue to you that these...
Do you object unless the entire transcript is read? Do you object unless the entire 6 hours is shown?
That is not my contention, but...
Well, but if you did, then I would require them to show the entire 6 hours of this jury.
And that is not what I'm aiming for. And I'm not standing here defending what Grant Hayes says, but it's being offered to show the truth of the matter asserted, that these things that he's saying match up, the aliens thing matches up with what is in this hearsay, which is in this parenting record, and therefore it's being offered for the truth of the matter asserted, and therefore I'd argue to you that it's hearsay, that That at this point, any conspiracy is over, and it's not in the furtherance of conspiracy, and there's no reason this should be admissible, but I understand the court's ruling.
I hadn't ruled yet. I'm just trying to get your contention about if I let any of this in, do you require that I let it all in? I mean, I think you have the right under the concept that if you let any portion of, absent some prejudice, let any portion of a document in, that the state's entitled to require that the entire portion come in, or part of an interview, unless it's otherwise prejudicial, the entire comes in. I just want to know, it would be my impression that a very limited amount of this, if probative at all, may be relevant on the question of the mental state of Grant Hayes during this extended time frame. I'm inclined to allow the defendant offering evidence, as she has the constitutional right to do, some leeway in presentation of evidence that she contends may be relevant to issues concerning her defense. Do you object to my limitation of the transcript, or is it your position that the entire transcript should simply be read?
I don't think that we need to read through the entire transcript. I think that we can accomplish through cross-examination showing the relevant parts where.
Okay, all right.
The other problem we have, though, is that I don't believe that Detective Falk has reviewed this transcript or knows anything about what appears on the entirety of this video.
Well, Detective Falk is a good officer, and he can read. And therefore, I believe he, unless there's some dispute as to the accuracy of the transcript itself, he can certainly be called to, by either side, to identify the document and read portions of it that his attention is directed to, unless it's the words used by Grant Hayes or the references are just inaudible or unintelligible. And I don't know the answer to any of that. I think we probably need to take a break and let y'all, let the defendant's attorney decide what portions he seeks to have the officer refer to, and also what portions that you may, if not covered on direct.
I have some further questions in that, does the playing of this defendant's interview, does that make, I'm sorry, the playing of Grant Hayes' interview, does that make Amanda Hayes' post-arrest mindset admissible?
Only to the extent of her credibility, which you've already inquired into on the witness stand. Obviously, if she made statements after her arrest that you contend are not truthful, that's an issue that goes to her credibility. All right, let's get the jury back. Is that they've already had their break and come back? All right, that's what I figured. All right, folks, how much time you need to do this? It's 10 o'clock. No, it's 10 minutes till 12. Looking at the clock backwards here.